attempted M unaliving or attempted unaliving, dangerous driving, the law. So this evening I'm here to discuss quite a somber topic. I should say nothing in here is meant to be any sort of type of legal advice. It's just a bloke on the internet looking at stuff on the internet. Do you know what I'm saying? But just to be clear, I'm not going to be discussing any active cases whatsoever. However, the information in this video, you might find it interesting in terms of piecing together certain bits of information in relation to dangerous driving and attempted M, and also a question of dangerous driving whilst intoxicated. Okay, so first of all, looking at attempted M or attempted unaliving, it's something that's triable only on indictment. There's a maximum life imprisonment potentially, and then there's an offence ranging. Now, just to say, I'm getting this information from the Sentencing Council guidelines, which the CPS and lawyers will look at when they're looking at, and judges will look at when they're considering what sentence to argue against or argue for, depending on whether you're defence or CPS, Crown Prosecution Service, and if you're judged, determine it after a trial or after somebody has pleaded guilty, what sentence to impose. And as you can see, the range for attempted M is 3 to 40 years, but potentially maximum life imprisonment. And just to say, for my American listeners or people in Canada or Africa, wherever you are in the world, this is, I'm talking about England, UK law, okay, for the avoidance of doubt. So it's not just a simple analysis. As I say, obviously the first stage, you'll have people will attend this in terms of court process. People attend for initial case management hearings. Then there might be a plea hearing where the person puts in their plea. Generally speaking, for a sentence and charge of that sort of significance, they're probably going to be in custody, and there is there's stages to go through in terms of preparing the case. As I say, you have the initial hearing where the charge is presented. Then you will have and they might put in a plea or not at that point. Then and before the charge is presented, obviously the Crown Prosecution Service would have considered what charges to place at that first hearing, which could be at the mags, even if it's serious, because what will happen, it will be transferred from the magistrates to it may well be the Old Bailey if it's an actual M, but an attempted, potentially Crown Court maybe. If it's an actual M, it would be definitely at the Old Bailey, Central London Criminal Court, I think it's called. And the case is essentially being kind of case managed, because there's documents that will need to be put in. So you'll have disclosure. You'll have disclosure. So the CPS will need to disclose all the documentation and footage or whatever the CPS have, and then you will have there might be requests for additional disclosure. There might be some unused material from that disclosure, and the defence solicitors will no doubt want to be looking through all of that. And then as the matter progresses, maybe a defence case statement gets put in, and further witness evidence, etc. And there might also be some, if there's an early There might also be some medical evidence put in, depending on the specific circumstances of the case, if it might support a particular type of case that is being brought. For example, if it's self-defense based on mental health or something along those lines, and or there might be footage from a particular incident which might be relied on. I mean, there might be a process of time where you take as much time as possible to get all the information together, either the CPS or the defence, to support the position that they're kind of pushing forward. Then you get maybe a pre-trial review, then you get to, and as I say, at each stage the defendant has an opportunity to plea. And I said the overarching thing is that it's innocent until proven, even though they're in custody or whatever, it's innocent until proven guilty. And you're not proven guilty, or you may not be proven guilty, depending on what the jury decides, until the end of the trial. But at each stage there is an opportunity to put in a plea, either guilty or not guilty, and you can get up to, I don't think it's a third or a fourth. If it's really early, you could potentially get a third off, then it's a quarter, and then I think there's not much, as the closer you are to trial, that you could potentially get off a potential sentence. Go through the trial. I think prosecution starts first, asks all sorts of different questions, and then defence presents their case. I think they go second, because at the end of the day, it's the person who's bringing the case who presents first, and then the judge will guide the jury in terms of the law. The judge isn't making any decision, it's the jury making the decision, the 12 jury members, and then they present their verdict, and then depending on what it is, if it's not guilty, then the judge will release the defendant. If it's guilty, then the judge has to consider sentencing, and they might not get sentenced immediately. They're likely to be subject to some sort of additional report in which the judge might want to review before making a final finding in terms of what the sentence should be. And that's not even necessarily the end of the journey, so to speak, because even if somebody is found guilty, they could potentially appeal to the Court of Appeal. And if their appeal's not successful in the Court of Appeal, they could potentially appeal to the Supreme Court. So there's quite a long way to go to the end of a trial, really. To the end of a particular matter. And I'd say I presented the ranges, and I'd say it's not a straightforward process. You can see there's different steps. You determine the offence category, culpability depending on what it is, higher culpability. So, for example, I've got to be careful about the language that's used here, but it's quite serious language. It's an informational video anyway, in terms of premeditation and this type of thing, or if it's excessive self-defense. So there's different levels: very high culpability, medium culpability, less culpability. So you could get self-defense, but it might be seen as excessive self-defense. And if it's excessive self-defense, it's still get charged. You still get found guilty, but in terms of the sentencing, it would be a much lesser culpability if excessive. If self-defense is proven, if the thing gets dismissed, as I understand it anyway, they also look at harm, serious physical, or other cases. So that is basically saying, is it a high level of harm or is it a lower level of harm? And then there's a starting point of category and range. And it's like you add you cross section the culpability versus the harm. So you start from the much higher level, which is the 35, then it can go down to as little as if you cross section a harm free with a culpability D, as you can see here, then you could get down to the 3 to 6 years. But as I say, the upper you get in the 35, and then if it's really, really serious, this all goes out of it, and it's just like the maximum life in that. But as I say, it's how the lawyers will make the arguments, the defence lawyers in particular I'm talking about, in terms of reducing the sentence. I should say the CPS probably wouldn't really be saying much. CPS probably wouldn't actually be saying much in the sentence element of it. It's more for the lawyers to present, the defence lawyers to reduce it. I mean, if there's any facts wrong, the CPS might pop in and say some words, or they might be invested from a public policy perspective to really make arguments as to why the sentence should be higher. But I mean, obviously their aim would be for it to be as much higher, but they too are guided by the sentencing guidelines in terms of how far they can try to push for a particular type of level of sentence. But there's other factors that take about previous convictions, any offences committed on bail, any hostility, in the characteristics, and also other aggregating factors which you can see set out there. Could be some personal mitigation which can also assist. If there's been history of violence towards the victim, towards the offender by the victim, provocation, no previous convictions, remorse, positive character, age, maturity. And this is where you kind of get the letters in from, family, friends, work, etc. Sole primary care for a dependent relative, serious medical conditions, pregnancy, childbirth, postnatal, difficult, deprived background. So those are factors that could come in terms of mitigation, and then you kind of consider any other factor would indicate a reduction, assistance to the prosecution, reduction for guilty pleas, and then they look at dangerousness. So there's loads of steps, and then up to step 8, air compensatory, totality principle, and then you got the compensation orders, etc. So I've kind of jumped a bit. I have given you the kind of stages through trials. So I guess that's useful, but I've kind of jumped to the actual sentencing. There is a case that I came across actually. General case. I'm not saying it's relevant to any particular cases going on at the moment, but this is a case called R v Riddle. So this is a case where the appellant was convicted. So they've obviously appealed to the Court of Appeal. So as I say, the end of the case isn't necessarily the end of the case. There can be potential further appeals that can take place, Court of Appeal, Supreme Court. And I'm going to make very clear, I'm not on any sides of anything at all. I'm just here to present information. I don't have a view on anything or any case. I don't have any views on anything. I'm just presenting information, just to be absolutely clear. But this is a case where the appellant was convicted at the Crown Court of making off without payment and dangerous driving from a trial before a judge and jury. The indictment was amended during the trial to include 3 counts: making off without payment, assault occasion, actual bodily harm, and dangerous driving. The jury returned the majority of verdicts of guilty on making without payment and dangerous driving. I'm just going to jump to the point here. In this case, this is the Court of Appeal, so this is a precedent-forming court. And one of the legal issues, this is the main point. One of the legal issues is self-defense capable in law of, and this is UK law for my American friends, my African friends, my Canadian friends, my South American friends, my Scandinavian friends, Spanish, Portuguese, wherever you are in the world. But is self-defense in the UK, England, in law of being invoked as a defence to a charge of dangerous driving? Okay, and then there's some other points about the judge's directions, and these were arguments that were raised. Appellant's arguments: self-defense should be available as a defence to dangerous driving. So that was the point that the appellant was raising, where the facts involved the use of force in response to a threat, and then the respondent argument, CPS no doubt, self-defense is not generally recognised as a defence to dangerous driving because the offence doesn't inherently involve the use of force. But the important thing is, what does the court say about it? What does the Court of Appeal say about it? And these are some cases that were referred to, and this is the rationale. What's it called? The ratio decidendi. the how the court made its decision. The court carefully analysed the distinction between self-defence and duress of circumstances, noting that self-defence requires only a genuine subjective belief of threat and allows for an unreasonable belief, whereas duress requires an objectively reasonable belief of threat or therefore serious injury. The court acknowledged that dangerous charges do not inherently involve the use of force, unlike assault charges, but recognised that in rare factual circumstances such as the present case, the use of force can be involved in the driving conduct. The court reviewed relevant authorities and found that self-defence has not been traditionally recognised. This has not been traditionally recognised as a defence of dangerous driving, but there is no legal principle precluding it where the facts involve use of force in response to a threat. The court rejected the submission that self-defence should be wholly excluded as a defence in all driving cases on policy grounds. So, I mean, they're saying essentially it can be a defence. The court noted that the unusual procedural history of the case, including the late amendment of the indictment. So this is the case called R.B. Riddle. R stands for the Crown Regina at the time, but now it'd be the King. Is it still R? Probably is, but it's the King versus whoever it is. The treatment of counts as alternate, and the judge written the direction conflated self-defence and duress. It criticised defence counsel. I'm not going to go into all of that, but the important point is, and you can see it highlighted here, is the court held that self-defence is in principle capable of, for a matter of law, of being available as a defence to a charge of dangerous driving where the facts involve the use of force in response to a threat. However, such cases are likely to be rare. So they're likely to be rare. So obviously in every case the court's going to look at the particular circumstances. I should say, just, you know, in this case it wasn't seen to be one of the rare cases because the court found no unfairness or unsafe conviction. So the court, so this is what you sometimes have, even though a matter may have gone on appeal, the court might make a finding in particular in relation to a particular legal point, but then on the actual facts of the case here, the court found no unfairness or unsafe conviction, so the person remained convicted despite making that finding. So it wasn't relevant to them in this case, but essentially the court held that self-defence is in principle capable as a matter of law of being available as a defence to a charge of dangerous driving. And what we must remember as well is, I appreciate that in any type of scenario, people on the defensive side, people on the CPS side, you know, maybe the family of the victim or a victim, they will have their views of a particular situation, and there's emotions, and they will run very deep. However, what the court is being guided, obviously the jury is looking at the fact, but in terms of the direction that a judge will give, the judge will give direction in cases such as Riddle, that self-defence is available, but it will be rare. So the judge is going to be directed by R.V. Riddle, and that's and it basically it just depends how a particular case is argued at a particular time by the lawyers involved. Essentially, it's as simple as that. It's as simple as that. All right. So that was R.V. Riddle. So there is a charge of causing serious injury by dangerous driving. Obviously, I've also looked at attempted M as well. But yeah, under the Road Traffic Act 1988, Section 1A, causing serious injury by dangerous driving, and that's triable either way. So that could be tried in the magistrates as well, but there's 5 years custody for that, and there's a range between 26 weeks and 5 years custody. I'm not going through the steps, but you can see that again the court is looking at culpability, harm, starting point and category and range. But as I say, self-defence is available generally, I suppose, so you know, but you have to prove reasonable force. Now, and in terms of attempts, it's under the Criminal Attempts Act 1981, where a particular, if with intent to commit an offence, Section 1, which this section applies, a person does an act which is more than merely preparatory to the commission of the offence, he is guilty of attempting to commit the offence. It's done in England and Wales. Even though the facts are such, the commission of a person may be guilty of attempting to commit an offence to which they apply, even though the facts are such, that the commission of the offence is impossible. So that's where it comes from, and there's some exception, but you know, I'm not going to go into that now. Drink driving penalties: 3 months imprisonment up to 2,500 fine. I'm not going to go through the limits, but there's also refusal to provide a specimen of breath, blood, or urine, etc. So those, and there is, I don't want to say causing by careless driving when under the influence, you may get life imprisonment, unlimited fine, abandoned for driving for 5 years, and extended driving test. I'll just flick past things that are not necessarily acceptable to YouTube. Now, in terms of mental health suspects and defendants, so again, I'm looking at all of these sites that they're publicly available, CPS guidance, sentencing counselling guidance, and before you know, this is stuff that the CPS will be looking at as well, and defendants lawyers will be looking at generally as well. So mental health suspects and defendants. So aside from self-defense, there are other defenses or things to take into account. Mental disorders, learning difficulties, learning other mental health, cognitive or neurodiverse, etc. And they may have a bearing on the decision to prosecute or not. So that's a stage for the CPS, really. That's the stage for the CPS, really. And I just thought that, you know, it does get taken into account on a decision to prosecute. But the important thing about this part, though, is that it would be for the defence team to provide that evidence, you know, to persuade the prosecution not to continue any further. Now, I think in really serious situations, I'm not seeing that happening necessarily. I don't think that would necessarily happen. You know, if there's serious injuries, etc. It'd be very difficult for public policy wise for CPS not to proceed to at least go through a trial, for the juries to make a decision on what's happening, because there'd be uproar, essentially. There'd be uproar. And there is CPS legal guidance on, which isn't coming up for some reason. I had that earlier on today, but there is some guidance on self-defense, etc. as well, that you could also look into. So I just thought that I would take a look at these two main topics areas: attempted dangerous driving and the law. As I say, nothing in here is legal advice or anything like that. Not bound by it and anything like that. It's just information that a bloke's looking at on the internet. But I thought, I don't know, you might find the information interesting to you. So please make sure you like, share, comment and subscribe. But for now, I'm done talking.